Hello, my name is Grace Albright, and this is my presentation on expert witness testimony. For our overview, we are going to be going through all of the steps of the criminal justice process. In each of these steps, we're going to delve at the appropriate times into the defendant's rights as determined by the Sixth Amendment, discovery, and how it differs in criminal and civil cases, the federal rules of evidence, specifically Rule 702 and 703, and the five parts of trial testimony. Now, the criminal justice process, I've broken it down into five different parts, beginning with the alleged crime. The alleged crime usually begins with an accusation of sorts related to a crime. There was a burglary, there was a murder. After that, depending on the accusation, as usual, there will be an investigation into what was said. So that means police officers will come out, they'll begin to collect evidence, and interview witnesses. It will usually be followed up, according to Hawk, by an indictment, which was a formal citation of the alleged crime. Now, before we go any further, usually at around the point of the alleged crime, it is good for the defendant to be aware of their Sixth Amendment rights. It says this heads to trial. Under the Sixth Amendment, there are five things that the defendant has a right to, which include the right to a speedy trial, the right to counsel, the right to confrontation. Now, this one, for clarification, it means that the defendant does have a right to confront or face any witnesses that takes the stand, any expert witnesses is that take the stand, with exceptions, of course, in cases such as sexual assault. Right to a trial by an impartial jury, and the right to obtain witnesses in favor of the defense, according to Smith. So all of these things are all protected under the Sixth Amendment, and this helps to guarantee that the defendant has just a generally fair trial. Now, second step of the criminal justice process is going to be discovery and deposition. So discovery is the portion of the trial that allows both sides to collect evidence prior to actually going to court. Much like this photo here is showing, it is a time whenever forensic scientists would perform their tests on any evidence that was collected. But the other thing that can happen is deposition. Now, deposition, according to Hawk, is the evidence that is collected under oath for court use later. These would be any recordings that are taken in of witnesses that would then be played in court. All of this is done under oath, so it's similar to being on the witness stand, but it's just done prior to the actual trial. Now, discovery does differ in criminal versus civil cases. So I'm actually going to begin with the civil cases, is because the civil cases have a lot of similarities to the criminal cases, with just subtle differences. In civil cases, they still have the duty to disclose. So that's if they discover any really pertinent evidence that could severely influence the outcome of the trial. It is the duty of either the prosecution or the defense to share with the opposing side. They need to take into account also expense versus benefit. So if there is a very high expense for discovering whatever it is they are discovering, if the expense outweighs the benefit, it probably is not the best course of action. And then in general, they have they're very similar to the criminal rules, but they have just small changes. Like, for instance, in the criminal rules, as we go over, there is Fifth Amendment safety. So the Fifth Amendment in the Bill of Rights says is the right to remain silent, best summarized as that. It allows the defendant to remain silent so that way they cannot be called upon by the prosecution to testify against themselves for fear of self-incrimination or the possibility of forcing a confession forcing a confession. It also allows the defendant, though, to discover via the prosecution's preparation. So the defendant is allowed to obtain some of the test results from what the prosecution has already done. And maybe then they can also verify it against their own experts that they would like to pull in. And lastly, an interesting thing that I found, according to the U.S. Department of Justice, the defense must also provide copies of a lot of the documents that they obtain, just for documentation purposes. Moving on to step 3 of the criminal justice process, we have any other pretrial preparation. So this is going to be the point where the defense and the prosecution and the lawyers and anybody else that they pull in is going to be prepping things like charts, exhibits, tests, or any summaries according to Houck. All of these things are going to be used, hopefully, to convey any sort of results or relevant evidence in a way that a jury can understand it much easier. So, for instance, any summaries that are done are for the purpose of making it easier for the jury to understand the evidence. Speaking of evidence, this is a good point to review the 2 federal rules of evidence that we are going to be reviewing in this presentation, starting with Rule 702. So this is testimony by expert witness. There are certain cases that happened during the course of history that helped to influence these rules and develop them into what we know they are today, beginning with Frye versus the United States. This photo in the slide is actually a picture of Frye being administered a deception test, which we now nowadays as a polygraph test. At the time that this test was used, the science behind it wasn't generally accepted or fully validated. And so a lot of the testimony about this deception test, including any testimony that was going to be given by the expert witness that administered the test, was dismissed by the court. And for right reasons. It wasn't generally accepted. It wasn't deemed tested enough in order to submit it as valid evidence. So Frye began the introduction of what is known as general acceptance. And then following that, Daubert versus Merrell Dow Pharmaceuticals expanded on the idea of general acceptance. It's because in the case of Daubert, 2 children were born with birth defects, and the mothers had taken a specific anti-nausea drug developed by Merrell Dow, and they claimed that this drug was the source of their birth defects. They submitted studies, they submitted what they thought was evidence. They had experts testify, but what they did end up submitting was not enough necessarily for it to be considered a generally accepted conclusion or a generally accepted claim that the anti-nausea drug that they were taking did cause the birth defects. And so their case, or that claim that they had submitted, was also dismissed and they were not ruled in favor of. So Daubert helped to expand on what the meaning of generally accepted is in terms of Rule 702 and the testimony provided by an expert witness. And then it moved on again to General Electric Company versus Joyner, where once again, and they expanded on the idea of general acceptance and what was considered relevant to a case. In the case of General Electric Company versus Joyner, Joyner was exposed to some hazardous substances while on the job. He didn't know they were necessarily hazardous until later on, and so he sued the General Electric Company. They tried to get his case dismissed, and this case specifically placed restraints on the appellate court for what they could dismiss as far as expert testimony or what they could let in also as expert testimony, because Joyner did provide a lot of relevant expert witnesses that helped his case a lot, but the appellate court dismissed them still as not valid enough. And so this case helped to develop, once again, what the testimony by an expert witness should look like, as well as place limits on what could be admitted and what could be dismissed by the appellate court. Now, Rule 703 helped to also define the bases of an expert. So what makes an expert witness? Daubert versus Merrell Dow Pharmaceuticals was kind of the foundation in the beginning of this type of development in this case, or this type of rule, making developments in that. Whenever they were specifying what needed to be submitted as far as evidence and the defining of general acceptance, it's in Daubert, it was Kumho-Tyre versus Carmichael that expanded on general acceptance in terms of what makes an expert witness. and what would be generally accepted for specialties with special knowledge. So those would be people like mechanics. They're not necessarily scientists because Daubert is very strict as far as what's an expert witness. And most of the time, under at least the definition by Daubert, the expert witness needs to be a scientist, somebody with a master's degree, a PhD, for example, any of those kind of cases. But Kumho Tire versus Carmichael opened it up to if a expert mechanic who has had 20 years of experience working on cars or tires, tire factory, if they decided to testify, it would be based off of their training and their practical experience and their special knowledge and how they were able to communicate it to a jury. So that is how Kumho Tire, at least, influenced the rule of evidence, specifically Rule 703. Moving on to step 4 of the criminal justice process, we have the trial. This is when it would begin usually with the testimony, at least of the expert witness, would begin with the expert witness qualification. So they would state why they are qualified. And it's very important to note as well that the expert witness is the only one that is under oath. Any witness that presents in court is the person under oath. So it places an extra emphasis on tell the truth. Always tell the truth. And also, according to Hulk, you need to be extra mindful of how you are presenting yourself, of how you are communicating the evidence, of making sure that you are using proper language. So that way the jury can understand, but you're also not making the jury feel, for lack of a better term, stupid, like they don't know anything. So it's very important for the expert witness to be mindful of what they are doing and how they are presenting themselves in court. Now, to break down the 5 parts of trial testimony for an expert witness, it's going to begin with what's called the voir dire. The voir dire is that portion where they're communicating their qualifications. So it's telling people what makes them an expert witness, what makes them qualified to testify. It'll then proceed with direct testimony. So this will be share what you know, share what you have done for the evidence, what were your results, what are your opinions, if necessary. But really, we want to stick to the facts in the direct testimony. With the cross-examination is going to allow the opposing side, so the defense of the prosecution, to question the expert testimony as well, if they wish to. This is then followed by redirection and re-cross-examination. So it could go back and forth between the prosecution and the defense, asking questions of the expert witness in order to clarify, re-clarify, restate any of the things that she or he had already said. And lastly, the judge is either going to retain the expert witness for further questioning later, or excuse the expert witness, and so their job is done. All of this, again, according to Hoke. Finally, though, we get to the end of the criminal justice process, which is the adjudication, or the verdict. This is decided by a jury or a judge. It is usually followed by sentencing, but there's a special emphasis placed on fairness because fairness must be considered for both parties. After all, the defense is still human. The defendant is still human. So the punishment must walk a line of being harsh enough or deserved enough that the prosecution feels like there is justice and there's closure for their client, but the defendant is also not abused by the punishment at the same time. And so it is rightfully earned, but within, of course, certain bounds. So this is the final step in the criminal justice process. So we have reached our end at this time. These are my references that I used. Thank you so much for your attention.